you. We first filed suit on May 17th, 2022. Once we filed suit, the case was put on a track, a discovery track. After the filing of a complaint, we expect the procedures for the defendant upon service to file his answer within the required time, after which the discovery period opens. So we perfected service, I believe, sometime in the summer of 2022, and that opened the discovery period. However, the defendant in this case, the Honorable Kennedy Agyapong, did not file an answer to the complaint. So the case went into default, and I believe sometime in 2023, we attempted to obtain judgment by default, at which point he retained counsel and filed a motion to reopen default. That process took about 6 months to get over. We consented at a point to the reopening of default, and he filed his answer subsequently. We had to wait for the discovery period to elapse. I believe this case was on a 180-day discovery period track. So we attempted to conduct discovery. We faced several challenges. The Honorable Kennedy Agyapong was generally uncooperative. We don't know if he didn't know about the case or there was some type of miscommunication between himself and counsel. So we proceeded to transcribe the video that is the subject of this civil litigation, and proceeded on to, after he filed his answer, he then followed up with a motion for summary judgment. We also filed a cross motion for summary judgment that took some time to be resolved by the court. And then we started heading towards trial.
People have been trying to understand something, that both are Ghanaian nationals. How come it is a court in the United States that is dealing with their case?
So when I first, when Anas Aremea, Anas first sent me the video of that is the subject of this this litigation, we took a look at the contents, and we ran it through a system that we have that ensures that we don't file frivolous cases. And we determined that based on his own assertions and some other research or investigative work that we did, that there was jurisdiction over the Honorable Kennedy Agyapong in Essex County, New Jersey, on account of his ownership of property there that he admitted to in the audiovisual recording that is the subject of this litigation. Then we also, for those who understand what I'm talking about, that gives us basically a general jurisdiction over him for all claims in that jurisdiction. Then we also, our research also supported the exercise of jurisdiction in terms of the conduct, the specific conduct that is the subject of this litigation. Because once again, he admits on the audiovisual recording that he is seated in his house in New Jersey, in West Orange, New Jersey. So that is the jurisdictional basis for bringing suit in Essex County, New Jersey.
So the comments were the interview he had with the second defendant was in New Jersey. He has a property in New Jersey. He was conducting the interview in that property. And therefore, it was easy for the defendant to sue there. That's the point.
Yes. And there's been they haven't objected to jurisdiction. So that has never been an issue in this case.
Jurisdiction was not objected to at all?
No, there was no objection to jurisdiction in this case. They made mention of it in passing in terms of, in
your system, we know that like here in Ghana, if you file a commercial suit, there is a mandatory settlement attempt. If it fails before it goes on litigation on a trial, we know that in your system, that applies to cases like this. Did you attempt to settle the case?
Yes, there were overtures made pre-trial, and then on Monday, I believe March the 9th, 2025, the first day of that we were scheduled for trial, we attended a mandatory settlement mediation in Essex County, New Jersey.
What was the outcome of that? Obviously, it failed. That is why it went to trial with the jury. But how did it fail?
We were just too far apart in terms of what we wanted out of the settlement conference and what the Honorable Kennedy Agyapong wanted out of the settlement conference. So essentially, negotiations fell apart, and we proceeded on to the courtroom. And
what did you want? What did you want, and what did he want?
Well, our complaint was we asked for damages in the form of compensatory and punitive damages to the tune of 30 million United States dollars. He made and then we decided to compromise for a little bit over half of that amount. But he was just too far from settling this case.
He was willing but too far. Is that what you're saying?
Yes, he was willing but too far.
What was he offering?
I think it's in the media. He offered us $10,000.
$10,000.
Yes.
Okay. So what did the mediator or arbitrator have to say?
Well, at that point, we were too far apart. So, the case just had to go into the courtroom for trial.
Okay. Okay. So now quickly, we are at the point of the trial. The jury's verdict, it was unanimous, as you say.
Yes. For every question that was posed on the verdict form, the jury returned a verdict in our favor, unanimously 8-0.
Okay, a unanimous verdict 8-0. That Ken had done what against Anas?
Well, there were several questions on the jury verdict form. Chief among them is the question of whether the Honorable Kennedy Agyapong had defamed our client, Anas Aremeyao Anas, and the jury answered that question affirmatively by a vote of 8-0. There were also several questions that honestly I can't specifically recall at this moment, but the most important is that the Honorable Kennedy Agyapong was found liable by the jury by a vote of 8-0.
Okay. So I've looked at the sheet, and there were the counts included that the plaintiff that he had made allegations in certain nature. So count 1, count 2, count 3, count 4, and 5. So on all 5 counts, the jury held that he was guilty.
I believe one count did not reach the jury, but on all the other counts, he was found liable to have defamed Anas Aremeyao Anas.
Yes. As we understand, he was relying on the judgment of the court in Ghana, that the court had found, as a matter of fact, when Anas sued in Ghana, that Anas was a tax evader, he was a murderer, and so on and so forth. And so he didn't say anything wrong.
Well, that's true, but it's not entirely accurate, because he relied on, first of all, those statements that the court made, which we believe are obiter dicta and are out of place, respectfully, occurred after the statements that he made. And the legal test in this case is whether or not at the time he made the statements, he had evidence that made the statements true. In this case, the answer was negative.
Right. Tell us, is this case over?
Well, the trial is over. I can say that. I can say that much. The judge at the end of the trial read the jury's verdict. There was a little complication where the jury sent a note explaining their verdict, which gave rise to certain assertions by opposing counsel. But the trial's over. The judge has now instructed that anyone who has a post-trial motion should do so according to the rules. So that's where we are right now. We've submitted a proposed judgment for the judge's signature.
Explain that. Has Anas, in fact, won a verdict for $18 million or not?
Yes, he has.
Is that verdict under appeal or question?
It is not on appeal because it hasn't been reduced to a written judgment yet. Like I said, opposing counsel made, I think, thus far he's made two applications after the verdict. The first was a application for remediature that was made immediately after the jury's verdict on, I believe, Thursday the 13th. I stand to be corrected. The jury came back on Thursday the 13th at around 5 p.m. Opposing counsel made a motion for remediature, which essentially is requesting that the judge reduce the damage award on a basis that it shocks the judicial conscience. The judge informed counsel that he had heard counsel, and because we were supposed to be back in court on the 18th, that was left open. And on the 18th, the judge basically informed counsel that he was not properly before the court on that issue. And then on that same day, the jury had other business related to this case to do, and at the conclusion of which counsel then made a motion for mistrial, which was promptly denied. So as we stand, per the rules, the next step is for the next procedural step is judgment. In spite of counsel's misgivings about what has transpired in court, his recourse lies in following the rules and filing the necessary post.
You say that he made an application for mistrial and that was shut down.
Absolutely, it was shut down by the court.
So are you able to say at the next court date, nothing will change about the jury's verdict of guilty of malicious defamation and an award of $18 million US?
Well, as we stand, we don't have a next court date. The trial is over. Subject to anyone following the rules and filing a post-trial motion as the judge instructed.